All right, title transfer. So when we purchase real estate, we acquire somebody else's title and it becomes ours, right? Yes? Okay. But there are methods of title transfer and we need to know what those are. Okay. If we don't handle it, then why do we need to know this stuff? We don't handle the title transfer, right? Who handles the title transfer? Lawyers, title companies. Usually we don't. No, Jefferson. Banks do not handle the title transfer. Banks, they handle the lending. Lawyers and title companies are the ones that prepare that transfer. Okay. So why do we need to know this stuff? To who? Questions to ask who? The property owner, for instance, right? Or also to advise the buyer. So just like legal descriptions, do we need to know this stuff? I mean, we're not surveyors, right? But we need to know the basics. Okay. A lot of the stuff that you guys are going to learn over the next couple of weeks is stuff that's specialized and that we don't get involved in. But if we don't know, how can we advise our clients? We can't, right? So this is why we have to go through this stuff. Good or bad, we have to. So real estate professionals who understand deeds and title issues will understand the transaction better and know what questions to ask. Okay. A knowledgeable real estate agent can alert customers to the need for legal advice and avoid title issues. Now, the title serves two purposes. Okay. One, it represents the owner's bundle of rights. Can anybody tell me what are the bundle of rights? Right of possession, right of exclusion. Without going back, do not flip pages. Enjoyment, the right of enjoyment. What else? Right of possession, right of exclusion, right of enjoyment. What else? Don't flip pages. I see some pages being flipped over there. Don't do that. The right to dispossess, so sell or transfer the property. Yes. And the right of? There's one more. Yes. Exclusion, we did that. Yep. Control the property. Encumber the property. Do everything you want with the property because it's yours, as long as it's within the boundaries of the law, right? So these are the rights we have. So title transfers those rights from the previous owner to you. Okay. There's a few. I'm not this one. It's like the pit yesterday, possession, interest, time. It's tough to come up with a real acronym for it. Some instructors do it, but you'll come up with one. Thank you. Some of them do. It's Poco Andy. That's what I say. But yeah, like Poco Andy.
Yeah, I know.
Like if you told me Pocahontas or something that will help. Like okay, but Poco Andy. All right, so title holder, the second purpose is evidence of ownership, obviously. The title holder can recover or keep real estate if challenged in court. Unlike a car title, which transfers ownership, real estate title is not a printed document. So this is one thing you got to remember. Title is not a printed document. So deed is not evidence of title. A deed is not evidence of title, okay? The only exception to the printed document is the Torrens certificates, which are limited to certain states. The second time I mentioned the Torrens certificate, right? In the previous chapter and now. Torrens certificates, which only exist in certain states, and the certificate itself proves ownership. Now, a sale or gift can transfer property title voluntarily, but a transfer title can also be involuntary by action of law. The property could be transferred while the owner is alive, and by will or by state law if the owner died without a will. Now, transfer or conveyance is known as alienation, which by legal definition means withdrawing or separation of a person or person's affection from an object or position of former attachment. The reason why I put this definition here is because in every book and in the exam, you're going to see the word alienation. Alienation, usually I separate this into alien, okay, Asian, right? I don't care about the Asian part. I want you to focus on alien. Alien is foreign, detached, right? So alienation is for you to detach yourself from the property. How do we do that? We sell, somebody else attaches to the property, they become the citizen. Think about a United States citizen versus an alien, which is somebody outsider, right? An outsider. So if you're born in a different country, you're an alien to this country, and vice versa, right? United States citizens are aliens to other countries. So detached, outsider, right? You, Fernando, you want to buy my house. You're an alien to my house. I'm the citizen of the house, right? Alienation is me separating myself from the house, transferring it to you. You become the citizen or holder of the title. I become the alien to the title. Does that make sense? Good, guys? Yes? What happened? You've been doing so great. There you go. There you go. Okay. So by definition, it is that detachment, withdrawal of rights or detachment. Now, we can have voluntary alienation. If it's voluntary, what does that mean? It means you're doing it willingly. You want to transfer the title. You want to sell the property or gift the property, right? Voluntarily. You can do that during your lifetime or as a gift in a will or an actual sale. The deeds transfers the property owner's rights, title, or interest to another party. Every state statute of fraud requires that the deed be in writing. We're going to talk about this a couple of times when we get to contracts as well. Statute of fraud, every state statute of fraud requires the deed to be in writing. Why? As the name says already, statute of frauds, it's to prevent fraud. All right. Do you guys remember when I said the other day that back in the Middle Ages, they used to transfer the property by grabbing dirt or the sticks from the tree, the branches, right? And just, hey, this represents the land, it's yours, right? Anybody can do that, right? So a lot of fraud happened back in the day, right? Imagine somebody at sea or somebody went to another country and here I come, like I do not own the land, but here's dirt, you can have it, right? So the reason why we put it in writing is because we can specifically name who I am as a seller, who you are as a buyer, and that we're granting or gifting the property to you. Does that make sense? All right. So the person who receives the property is called the grantee, and the grantor is the property owner that grants, sells, or gives the title by signing the deed. The table below lists the terms that can be remembered similarly. This is something you have to remember. The product is the document that's being drawn. That's the product, okay, or property. The property owner is on this table right here. And the recipient is, I'm sorry, on the column, and this is the recipient. So this will help you distinguish the OR and the E. Where a lot of people make a mistake is this one, by the way, I'm just going to point it out. But this is what you have to remember. If it's a devise or somebody willing the property, we devise the property. The devisor is the one that creates, owns, and gives the right. Okay? The recipient is a devisee. If it's a deed, somebody's going to grant the property. So it's a grantor or owner of the property. And who receives the property is a grantee. If it's a legacy, so personal property being transferred, it's legator, legatee. If it's a lease or a rent agreement, there's a lessor, the landlord, and the lessee, the tenant. Okay, you see how this works? OR is the one gifting the right. E is the one receiving the right. Here's the complicated one, and we'll address this in mortgages again. Who is the mortgagor and who's the mortgagee? Mortgagor is the one giving the right. The mortgagee is the one receiving the right. What does that mean? Who is the mortgagor?
Bank.
Wrong. Wrong. Who gives the mortgage?
Oh, you were the bank.
We do.
Oh,
The bank gives us money. We give the mortgage to the bank in exchange for money. But I'll cover that once we get to the mortgage chapter.
so the bank is a mortgage.
Mortgagee. Look at this reference down here. Think of OR as short for owner. This is why I was showing you a pattern over here. Property owner, devisor, grantor, legator, lessor, mortgagor, offeror, optionor, sublessor, and trustor. The or is the short for owner. Remember that. Owner. The E receives the property or the document. Okay? OR is the one gifting that right. So we give the mortgage, and now again, we have a chapter for this. We give the mortgage in exchange for money. Once we pay the money, they have to release the mortgage. Okay? All right. I'll ask you again in a couple of chapters, and you will screw up again, which is normal. Even real estate agents, after they get licensed, obviously, because now they're agents, even they don't know. They knew it to pass the exam. It sucks, but just so you know, that's what you need. You need to pass an exam and then become a realtor. Right? That's it.
Realistically speaking, after we pass, like most of this information, it's not gonna retain.
Yeah. So unless you go, but even mortgage people, the loan officers, when they talk to you, a lot of the terms that I'm going to explain when we get to the mortgage chapters or financing chapters, even the mortgage people simplify it for you. Oh, we're going to get you a mortgage. No, you're going to get a loan secured by a mortgage. But the loan officer says, no, I'll get you a mortgage. Do you understand what I'm saying? We're going to talk about things like PMI or MIP, private mortgage insurance. When the loan officer talks to you, they'll always say PMI, even though there is a difference between them, PMI and MIP. It depends on the type of loan that you're getting. The purpose is the same. It's an insurance, right? But it depends on the type of loan. So if you're getting an FHA loan, it's MIP. But loan officers already know the terms. Either they forget what the difference is, or they already know that you know that term, PMI versus MIP. So to keep it simple, they'll go with it pretty much. And you guys as realtors will do the same. Sometimes you'll know the terms, sometimes you won't remember the terms, and you just say whatever people are already used to, because that's what you as a customer or consumer of the product are used to. Okay. All right. But to pass a test, unfortunately, what do we need? To know the terms and the difference between them. Okay. All right. What are the requirements for a valid deed or for a deed to be valid? Well, for a deed to be valid, a grantor has to have the legal competency to execute a deed. What does that mean? Legal competency? You guys tell me? I thought you were going to say something. What does it mean to be legally competent? We're going to go over this anyway, but what do you think it means to be legal?
Like of age, mentally stable.
That's it, of age and mentally stable. Okay. Now the of age part varies from state to state. In some states, you could be 16 and be legal adult. Other states, you cannot. In some states, if you're 16 and married, you're a legal adult. Okay. But you got to be of sound mind. The next one is the grantee must be named with certainty. With certainly reasonable certainty to be identified. All this means is your name is there. Believe it or not, when you look at a deed, you're going to see John Smith. Like, how does that identify John Smith? Which John Smith are we talking about? There's no real identification of it. There has to be a statement of consideration. Consideration means exchange of value. Consideration means exchange of value. What does it mean, exchange of value?
Like, what is the statement of exchange?
It has to state what was being given in exchange for that deed.
Okay.
So if I'm selling you my house, what did you give me in return? 300,000, 400,000, $1 million. a car. You see what I'm saying? There has to be a statement that identifies what was the exchange. $1. Yeah, it could be. Granting clause. Obviously, words of conveyance or transfer. By the way, conveyance means transfer. This means exactly the same. It equals transfer. So granting clause, that I grant my property or the title of my property to you. There's the habendum clause, which outlines the ownership right that the grantee has obtained, an accurate legal description of the property being conveyed. Who can tell me what types of legal description exist?
Land.
Well, land description, yes. Which types? Meets and bounds.
Lot, lot.
Oh, now you know. Lot and block, okay. What else? Michelle, write the whole thing. It's not just survey, because all of them could be surveyed. Don't go back in the pages. We just
Rectangular.
really one break and that's it. It's gone. A blank. Whew. Imagine if you don't study. Who did the 60-day commitments? Okay. 20 minutes went by and you already don't remember the legal description. 20 minutes. Imagine in 60 days. You better study, okay? So meets and bounds, rectangular survey method or government survey method, and the block and lot. Absolutely. The deed also has to include any exceptions or reservations. We did talk about deed restrictions yesterday as well, right? Any acknowledgements, so notarization or signature, and delivery of the deed by the grantor and acceptance by the grantee to transfer title. A deed may include a description of any limitations on the conveyance of a full fee simple estate and a statement of any exceptions and reservations, also known as subject to or contingency clauses that affect the title to the property. We talked about fee simple absolute, fee determinable, conditions subsequent, life estates, right? These could be easements. It could be a condo where you have common elements with covenants, conditions, and restrictions, and so on, okay? All right, so we already talked about what a grantor is. It's the person that gifts or grants the property, right? So the owner of the property. In most states, must be 18 years or older, right? So accordingly, if you're considered a minor, this might be a question in the exam. Let's say it's a 15-year-old that is transferring a title. If you're 15 years old, in most states, you're not an adult. So can we transfer title? See, here's the thing. They consider this voidable, not void. Voidable means if the minor says, hey, I don't know what I'm doing, I want to cancel this, then they can void it. Okay? Voidable is different than void. Void means it has no effect. Voidable means that you can void it at a later time. Okay? So that will be from depending on state law. But in New Jersey, for instance, and we'll talk about this when we get to the state portion, so you don't have to write it down yet. But in New Jersey, if you're 16 years old and you're married, you are a legal adult. So it's permanent. It's not voidable. It's an actual enforceable contract. But if you're 16 years old and you're not married, you're a minor. Once you reach the age of 18, you can say, oh, wait a minute. I didn't understand contracts until today. As if an 18-year-old understands contracts, right? Most adults don't understand contracts. But you reach the age of 18 and you said, nope, I didn't want to do that. I don't understand that. And automatically you can void. So if you got it, let's say you got a credit card when you were under 18, you literally could tell the bank and say, hey, I was a minor. Get that off my credit.
Yeah.
That's the easiest thing to remove off your credit because you were a minor. You did not understand contracts. You got it? A property. Let's say I have a property with my son. My son is about to be 16. Let's say we got a property together when he was 5. That's what we do. We invest in our kids, right? So once he reaches the age of 18, this property that has both our names, he reaches the age of 18, what can he say? Dad, real estate is not for me. get my name off that property. I don't want to deal with this. Can I force him? No, because now he's an adult. You see what I'm saying? Can he say, hey, I want to keep going at it, like my name is there, and I'm like, no, you're not my son, get out of here. Can I take his name out now? No, he's an adult. So it goes both ways. They can either affirm to stay, or they can disaffirm or void the contract, either or, once they reach legal age in that particular state. Yes.
What if, let's say you're 15 and your grandma leaves you her estate, so with your name,
Mhm.
and you decide, I don't want this house, I want to sell it and I want the money.
Mhm.
So you sell it. How would it be avoidable when you're 18? At that point, it would be too late, right? You can't do anything with that.
So here's the thing. So the question was, if you guys did not hear it, question was, what about if you're 15, you inherited the property, and then you sell the property? When you reach 18, would that contract be void? Right? Whatever, it's probably too late because the action already happened. The contract is voidable while it's in effect. If we closed, we closed. Does that make sense? Okay. It's going to be very tough for you to get back. That's one of the things we're going to talk about as well, possession. When you're in possession of the item, right? I don't know if you ever heard possession is 9/10 of the law, like adverse possession when you're a squatter, right? The fact that you're there and you're using it, right, solidifies your position on that property or on the title of the property or the ability to use the property. Once you let go of possession, so in the case of what you said, the sale, once you let go of possession, then it becomes way more difficult for you to go back. All right. But if you're in the middle of a contract and you say, you know what, I don't understand none of this, I want to back out, until the closing date, you can just back out. And the buyer cannot sue you because you are a minor. Okay. Now, in those instances, usually when you inherit the property and you're 15, there's a guardian. Okay, there's somebody, an administrator or trustee that will handle the affairs until you are 18. Okay, so bringing the reality to it.
Yeah.
That's what it is. But good question. All right. Legal competency, we already talked about it. Now, a deed that's executed by someone who's mentally impaired is voidable, but not automatically void. So the same thing as a minor. Throughout the deed, the grantor's name must be spelled correctly, and if the grantor's name has changed after marriage, both names should be shown. So let's say you got divorced or you got married, either or. It used to be Jane Jones, now it's Jane Smith. The name has to be exactly like that. What the current name is and what the former name was. Okay. Grantee, so a deed requires a grantee to be explicitly named so that the property's recipients can be easily identified. The granting clause should specify each grantee's property rights, and the clause may say that grantees be joint tenants or tenants in common. Question. What is the main feature? You have a question or you just have your hand up? Oh, okay. Oh yeah, because you got it. I don't know. He was like this. I'm like, okay, is that a question? But I do have a question. What is the main feature of joint tenancy? Main feature of joint tenancy. Without flipping pages, without going back, what's the main feature of joint tenancy? Why would I choose joint tenancy over tenancy in common? Elizabeth for the win. She was faster. I'm sorry. That was it. That was it. Elizabeth won. All right. Right of survivorship. That's it. Why would I want this? Because if one of the partners dies, I automatically receive or collect the shares. Okay, that's the benefit of it. Okay, very good. Sorry. All right, consideration, you guys already know it's the exchange of value, right? Now, usually this is expressed in dollars, but it could be love and affection as well. So remember I said I have my son in one of the properties? What did my son pay for? Nothing. So the transfer or anything that I have with him is based on love and affection. All right. The reality is I do make my kids pay for stuff, but but in this case would be love and affection. They have to learn the hard way, right? It is customary in most states that there's a nominal fee, could be $10 and other good and valuable consideration. Could even be $1, as was stated before by Stephen, right? Granting clause. So there has to be something in the deed that says, I, John the seller, convey and warrant. I, John the seller, remise, release, and alienate and convey. Depending on the type of deed, and we'll talk about that later, depending on the type of deed, it will take different forms. Okay, this is based on the type of deed. Now, a deed that conveys, what does the word conveyance mean? Transfer, very good. A deed that conveys the grantor's fee simple interest usually states to Jane Buyer and her heirs and assignees forever. So it becomes theirs forever, unless there is a restriction. So if it's fee simple, you already know, full rights. Okay. If there's a restriction, then obviously, like a life estate, for instance, then obviously you would say to Jane Buyer for the duration of her life. So it'll be explicit to that particular purpose. To Jane Buyer for the duration of her natural life. Speaking of natural life, if it's a corporation, do you think a corporation can own a life estate? Why not? There's a lot of different lives in the corporation.
Work for a corporation, so it can't be like one.
Because a corporation does not have a natural life, it has a legal life, which could last forever. So kind of like what you're saying, which could last forever, right? Or it could be dissolved at any point. So that's why a corporation cannot own a life estate or a joint tenancy, because of there's no survivorship in the corporation. Habendum clause. What's up with weird words, right? Habendum clause. And I removed, there's tenendum, there's redendum, there's a bunch of other endums. But habendum clause. The habendum clause follows the granting clause, where I, Bruno the seller, give the property to Jane Buyer, right? Ready? To have and to hold. Where have you seen this before?
Marriage.
In sickness and in health, in marriage, yes. So you're giving here's the ring, right? And you're giving the powers to have and to hold. That's it. You become my possession and I become your possession. Crazy, isn't it? That's what a habendum clause is. And then they go like, you're not the boss of me. Yes, I am. Look, you signed it right there. The kids is a little different. Like when they came out, the doctor didn't say, hey, here's your baby to have and to hold. No, just hold.
Don't drop.
Don't drop. All right. Now, if the grantor simply conveys a timeshare interest or interest less than a fee simple absolute, the addendum clause will limit the owner's rights to a specific time frame or a certain prohibited activities. So this is where it describes the type of possession or the type of ownership you have with your property. That's what the addendum clause does. All right, the legal description, we already talked about it. You already know that it's the government survey method, the lot and block, and obviously the meets and bounds. Exceptions and reservations, you guys already know this as well, right? It's when we say the property is yours as long as you don't do this or you don't do that, or if this happens or that happens, that's the type of ownership you have. Signature of the grantor. If a document has to be in writing, there's a few exceptions, which we'll talk about in a different chapter. If a document has to be in writing, then obviously there has to be a signature, okay? Notice that says signature of grantor. Do you see signature of buyer, of grantee? No, so only the person granting the title has to sign this. Only the person granting the title has to sign it. Put a note somewhere that only the grantor, the person granting the property has to sign it. Okay. Now, in some states, it is required that the signature be witnessed or notarized. In some states, the grantor's spouse must sign the deeds to waive marital or homestead rights. Okay, Connie. What are marital or homestead rights? You guys know? Did we talk about this? You don't think so? Elizabeth for the win again. Dower and courtesy. Oh, we did talk about it. All right. Elizabeth has Google, like search right there. Boom, bow, bow, bow. Like quick on the draw. Shaking your head. No, you don't. Okay. So dower and courtesy, right, are the rights where a husband receives the properties, the deceased wife's assets, or vice versa. Okay. So if we own property together, we both have to sign. That's law. Done. Everything. If we own it together. If you own property, you guys probably remember this because you were saying 19 something.
87, I said.
Okay.
Said I said 7.
But if you guys remember, I mentioned May 28, 1980 in New Jersey, for instance. You don't have to know the date. It's not going to be asked in the exam. But May 28, 1980, dower and courtesy ceased to exist in New Jersey. Now we have joint tenancy or tenancy by the entirety, right? But before that, when dower and courtesy was in effect, if I owned the property, but my wife's name was not on it, we both own it, no matter what. After May 28, 1980, what I own is mine, what you own is yours, and that's it. Unless we talked about contributions and all that. So if you know that somebody's married, you don't need to ask when they purchased. You automatically ask them to consult an attorney because both parties might need to sign to waive their rights. Okay? Because if it was before May 28, 1980, you cannot sell on your own. You need your spouse's signature to waive his or her rights to the property. Got it? So grantor signature. Anybody named, so all named grantors have to sign it. And if they're married, the spouse might have to sign as well. We're not going to start with prenup again, Nadia. Nope. All right. Next thing we got is acknowledgement. Ooh, I see a diaper somewhere. Michelle, like waving the baby's diaper right there. And the baby. All right. So an extra $5 for diapers on screen. Acknowledgement. What does it mean to be acknowledged? Simple. Boom. Notarized. Recognized. To know that that signature, under oath, that signature is genuine and voluntary. You're not being forced to sign it. You are who you say you are when signing this document, and you're not being forced to. The declaration is made before a notary public or an authorized public officer. An acknowledgement states that the person signing the deed or other document is known to the officer or has provided sufficient or enough identification to prevent a forgery. An acknowledgement is not required to make a deed valid unless required by state law. Most states do not require it to be acknowledged or notarized. Now, depending on the purpose, a deed that was not acknowledged may not be legally sufficient. And I'll tell you when that happens. If you're trying to refinance your property, for instance, if the deed is not acknowledged or if the deed is not recorded, right, then the bank is going to say, hey, you're not the owner. I searched public records. We just talked about this earlier, right? I searched public records and I don't see your name on it. Oh, but I have the deed in my hand. I got the deed in my hand. Well, yeah, it's not enough. Need it notarized, showing that the seller actually sold it to you. You cannot just claim to be the owner. right? So that's why it's so important that to have it notarized, even if the state does not require it. State of New Jersey does not require notarization. State of New Jersey does not even require you to record it into public records. But you should automatically do it. Okay? Most states, a deed cannot be recorded into public records if it's not acknowledged. Okay? The deed that was not acknowledged cannot be recorded. If it was not acknowledged, it cannot be recorded. We good so far? Yep. All right, the next one. Very important. Delivery and acceptance. This is super important. This is extra super important. Okay. Here's the thing. I have a deed in my hand, right? And I'm saying this is my property and I'm giving it to you, right? If you don't take it, are you accepting this gift? Are you accepting this sale? No. You got it? So not only does delivery have to happen, you have to take it and accept it for the transfer to be valid. This is a guaranteed question in the state exam. Delivery and acceptance must happen. So they'll have a whole scenario. If acceptance is not there, or if delivery is not there, then the deed did not transfer. The property did not transfer ownership. Okay?
Does it need to be like a third party present? To like know that, like to.
Nope. The deed doesn't even need to be dated. Actually, it says right here. The title changes hands when the deed is delivered and accepted, and the date of deed delivery becomes the effective date of title transfer. So do I need to have a witness? No. Okay. But let's go by common sense, since you asked that question. By common sense, does it need to be notarized? No. Should you? Yes. Does it need to have a witness? No. Should you? Yes. Okay. Just to protect your interest. It's not needed, but you should. Sorry, you're gonna say something?
No, I was gonna say like, what if you deliver me something and I don't accept it, but there's no one that saw me not accept it, you're like, I gave it to her, she accepted it, and that's it.
Well, but now, well, yeah, it becomes a challenge, and you can say you have it, you can say you don't have it, and that's it.
Yeah.
But who's gonna say that? I mean, the buyer would be the one saying, no, but he gave it to me. The seller is like, I got my money, I don't care. If you wanna do something with it or not, that's up to you, right? But if you don't, can I show up and say, I never gave it to you, I got the money and I want the property back? If there's no proof, then yeah, I could be that type of guy. Here's a house. I go search public records a few months later, nothing in the records. Right? But then there's other things. How did I get the money?
Generous.
No, how did I get the money? You gave me a check? Did you wire the money? So it goes back to what I was saying as far as marriage, right? It could be your house, but if I put sweat equity, like if I went there to work or if I put money into it, right? If there's any type of paper trail or anything that identifies that this is what we intended to do, right? Then the transfer actually happened. We'll address more of this when we get to the statute of frauds in New Jersey. If you have clear and convincing evidence that this is what we intended to do, then it happens. Okay. Should you rely on clear and convincing evidence if it was a verbal agreement or that if you didn't record? No, you should obviously put it in writing and always record it. Okay. Execution of corporate deeds. So if you're an individual or individuals transferring the property, everybody signs. But when you are a business, does everybody sign? No. What they sign is a corporate resolution right here. Corporate resolution that says, hey, Masha is the one that's going to be representing us. So that authorized officer, there you go, authorized officer signs the deed. So the only way that corporate property or property under a corporate name could be transferred is if we all agree to it. Okay? All right. Real quick on the different types of deeds. Ready? Ready? We have general warranty deed. Love it. General warranty deed, we have special warranty deed, we have bargain and sale deed, quitclaim deed, deed of trust, reconveyance deeds, trustees deeds, and deeds executed under a court order. The most common ones across the board are general warranty deed, special warranty deed, bargain sale deed, and quitclaim deed. These are the most common ones. These two, they go together. I'll explain better when we get there. Either one of these could be related to each other. I mean, this could be for this, or this could be for reconveyance deed. All right, so general warranty deed. First of all, what is a warranty? A guarantee.
Good.
You forget?
I know, the guy would give me like, has, maybe we can change it, like, we can do.
You can return. So it's like a guarantee, a promise, right?
Exactly.
So what we're saying is, I'm giving you the deed, you become the owner, but then there's a bunch of guarantees here to say, hey, if anything is wrong with this,
Yes.
come back. Just like when you buy a car, just like when you buy electronic, right? If there's anything wrong with it, go back to the manufacturer. Who's the manufacturer in this case? The seller that gave the property with a warranty. You got it? Now, there's general warranty and there's special warranty. There's a big difference between these two. Okay? We're gonna get to that. So general warranty guarantees everything. That's the name already says general. Everything is guaranteed. And it binds the seller or the grantor. In most states, the warranties are implied by statutory language. Some states include the grantor warranties in the deed. Each state law should be examined, but some phrases are generally conveyed as warrant or warrant generally. These are the basic warranties. We have the covenant or warrant. This means the same. Covenant is a promise or a warrant of season. Okay, this word right here, season, this is in my hand, it's mine. Taken away from me, I'm seized of the property. It's no longer mine. Somebody took it, seized my property. Okay, so the covenant of season is, hey, it's mine, right here. I guarantee that I own, and when I transfer to you, I'm seized of the property and all the rights that go with it go to you. That's pretty much what it is. If this guarantee is broken, if it's broken, the grantee can recover the full purchase price. So I'm telling you guys, this mouse right here is mine. I own it. But it's just my word, right? Did you verify anything so far? No, you just know that it's in my hand. Remember, possession is 9/10 of the law, right? And also 9/10 of the lies, because I'm telling you this is mine. It's not. Who does this belong to? New Direction School. Very good. All right. But I'm selling it as if it was mine. Right? And you buy it. And then here comes New Direction and says, oh, wait a minute. Where's the mouse? Well, Alexis has it. If they try to sue you, right? And I have to separate myself because I'm an individual, New Direction is a company, right? So if the company tries to sue you, what can you do? You can come after me for the full purchase price. Got it? Because I'm the one that guaranteed it was mine. Jefferson, I'll address that in a second. The next one is covenant against encumbrances. What is an encumbrance, guys? Who can tell me? These words should start getting familiar, right? What is an encumbrance? A burden, a claim, a cloud, a lien, a cloud. Yes, very good. An encumbrance is anything that holds back the title. Right? So somebody has a claim to the property. Somebody has a financial claim or lien to the property. An easement is an encumbrance. Right? A license is an encumbrance. Deed restrictions are encumbrances, right? Did we talk about this already? I just want to make sure I did, right? So if I'm saying covenant against encumbrance, right? Covenant against encumbrances. What am I saying? That it's a promise that there's no liens or other encumbrances, types of encumbrances against the property, right? I am promising, that's a covenant. So you as a buyer shouldn't have to worry. Nobody's going to foreclose on you. Nobody's going to take property from you. Does that make sense? Right? Except the ones stated in the deed. Which encumbrances can we find in the deed? Easements. Very good. Okay, you got it? That's an example. So those you'll find in the deed, because if it's a shared driveway, can we remove that encumbrance? Can we say, no, we're gonna cut this? I only want half of the driveway, my car goes sideways? Right? No. See, she's laughing, my joke's away.
Think about it.
Gotcha. That's it, gotcha. All right. The next one. Covenants of further assurance. If the name says further assurance, that means I promise and guarantee even more than what I've guaranteed so far, right? So that means that I promise to obtain and provide any document that is needed to make this title valid. So if there's any issue in the future, don't worry about it. Come back to me. I'll fix it. Okay? Just like the manufacturer's warranty. If the car breaks down because of the manufacturer issues, not because of you not changing the oil, right? If it breaks down, come back. I'll take care of it. Okay? I'll do whatever. Just come back. The next one's covenant of quiet enjoyment. That's one of the rights we have, right? Quiet enjoyment. Is that one of the rights? Right of possession, right of exclusion, the right to use and control and encumber the property for with any legal matter, right? The right of enjoyment, the right of transfer or disposition, right? So now I'm promising you that you can enjoy the property. Don't worry about it. There's nobody that has superior title to mine. Not only do I have possession, there's nobody that can claim the right to this mouse. All right. If the title is bad, I will compensate you for any damages. Nobody, no third party can come after this. Okay. Are we good so far? Yes? Cool. All right. The next one, the most ridiculous claim ever. Actually, there's another one even worse than this, but most ridiculous claim ever. Warranty forever. Who in their rights, not even car dealers are guaranteed forever, right? Manufacturers go like it's 10 years and that's already a stretch. We're going to limit this guarantee. It's 10 years, but this is not covered. That's not covered. The other thing is not covered. And like, hey, pretty much we're not covering anything, right? In this type of deed, we're warranting forever. That means, Masha, I sold it to you. You sell to Alexis. Alexis sells to Fernando. Fernando sells to Nadia. Nadia sells to Joshua, and it keeps on going. Years go by. Now, Joshua's trying to sell the property to Samaya. And here comes the seller, the one that sold to me, the seller's grandson, and says, oh, wait a minute. That property belonged to my grandfather. You, Bruno, never had the right to sell the property. Okay. What happens next?
You guys have to hash it out. Like,
We have to hash it out. Stick it outside. Let's go. Go. That's it. We got to go to court. But I'm not the owner of record. Joshua is.
Doesn't matter, you're giving the forever one. Okay, but where does the lawsuit start?
Okay, but where does the lawsuit start? Joshua is. Doesn't matter, you're giving the forever one. Okay, but where does the lawsuit start? Joshua is. Doesn't matter, you're giving the forever one. Okay, but where does the lawsuit start? They cannot sue me. They have to sue Joshua first.
So everybody's gonna get. sued?
Everybody gets sued until we can be proven that you acquired the title properly. And it reaches all the way to me, the person that transferred the title without the right to transfer it. So everybody gets sued. Absolutely. Congratulations.
Okay.
We all go to court. Now, obviously, everybody's going to excuse themselves. No, I got it from this person. This person got it from this person. This person got it from this person. Who got it from that person? Got that person got from Bruno. Who gave the warranty, the general warranty forever. Now, you know what gets crazy? Crazier is that these promises in the general warranty deeds, they go back to the property's beginning. Not only am I guaranteeing the future, the grantor defends. So the seller, me, I defend that every single owner before me acquired the property properly. So remember when they were transferring dirt, say, hey, here's dirt. Yeah, it was their dirt. They could have transferred. That's what I'm promising and guaranteeing. How can I do that?
How do you verify that?
You don't. But here comes somebody's grandson or great grandson, right? Or somebody from a former tribe that goes like, hey, and I'm running wind. And as running winds from this tribe, whatever, right? I'm entitled to the property. It was never this person's to transfer. I'm like, who's that person? Well, 100 and something years ago, that's the person that sold to this person, that sold to this person, that sold to this person, and it came all the way down to you.
Those lawsuits actually happen.
So this does not happen anymore because general warranty deeds are not as common. But yes, back then when I wanted to convince you that this title was good, this was the type of deed. When everybody was cowboys.
When would you ever give that warranty?
Back then, see, but that's the thing. Back then, who would dispute title?
There's no way to verify
I'm
anything.
carrying a gun.
Yeah.
Obviously, I got the land by killing somebody at sundown. You know what I'm saying? So are you going to dispute this? No. It is my land. I'm guaranteeing you, if there's any issue, come back.
Let me know.
Let me know. Nowadays, this doesn't happen anymore. Nowadays, we have what's called special warranty deed. Okay? This, especially in New Jersey, is the most common deed. Special warranty deed, also known as a warranty deed against covenants against Grantors Act. So that's a deed that's special or limited. Probably you've heard this before, limited warranties, right? What is a limited warranty?
It's only guaranteed for specific. There's restrictions on it.
There are restrictions on it, right? So in this case, we don't have a general warranty where we cover everything. We have a special or limited warranty. I'm telling you, okay, there's a limit. And I only cover during my grantor, my ownership, sorry. This type of warranty, it's limited to while I owned it. Isn't that much better?
Yeah.
Like I bought the property 2 years ago. I know what I've done over the past 2 years. I have no idea what the previous owner did, and I don't care what you're going to do after. I'm guaranteeing that while I had the property, I had a mortgage, 2 mortgages, I had a mechanics lien that I took care of, I had a tax lien I took care of. That's all I'm guaranteeing. From here on, it's your responsibility. Does that make sense? Right, a lot better. All right. So the grantor promises to defend title just like they would in the general warranty, but only against the grantor's actions during the grantor's ownership. Okay. Any questions on this one? Let me know. No questions? We're good? Awesome. The next one is bargain and sale deed. bargain and seal deed, also called straight bargain and seal deed. And as the name says, there was a bargain or negotiation and there was a sale. Okay. A special warranty deed is also called a bargain and seal deed, but we have it separate here on purpose. Because this one is by itself. There's no expressed warranties. Okay, so when you see bargain and seal deed by itself, there are no express warranties. If there are no express warranties, what am I guaranteeing? Only one thing. That supposedly I'm the owner.
Are you guaranteed?
That's the only thing that comes with it. It's like an implied thing. If I have it in my hand and I'm selling it to you, it's implied that I have the right to do so.
It's not guaranteed.
Not really.
So you're guaranteeing them.
It's the only kind of guarantee. Well, there's one that's even worse than this one. Okay. See, this deed is usually used for foreclosures and tax sales transfers. This is where the bank says, hey, I acquired it because they owed me money. I don't know if there's anybody else that's entitled to the property, but I went through the legal process and I acquired it. Maybe somebody has superior title to mine, but no claims were put, so I'm taking over and I'm selling at an auction to whoever buys it. So pretty much the buyer is buying at their own risk. Does that make sense? That's why it's very important to always do title searches. Always. The bank or whoever is foreclosing really don't care. They acquired the title through a legal process of foreclosure. Court gave them that power, and that's it. Okay. But then we got something called quit claim deed. Quit claim deed. What do you think this means, just by the name itself? Just by looking at the name. Sometimes by reading, just like that question about the trust, if it was a trust, right? Sometimes it's that obvious.
Somebody left the property for somebody else to pay.
Okay. No. What does it mean to quit? To give up, right? What does it mean to have a claim? What is a claim? Kind of. What is a claim? To be able to receive something. It's a right, a benefit that we might have in the property. When we quit that claim, we're saying, I don't want anything to do with the property, right? We're quitting. Now, a quit claim deed is used mainly for intrafamily transfers or during divorce, or even to fix issues on the title. So let's say I have a property under my name and then I get married. Okay. When I get married, what do you think is going to happen? Nadia, don't answer this one because she's going to say hashtag prenup. But
Now it's gonna be good.
yeah. So what happens is I'm 100% owner of the property, right? I'm 100% owner, but now that I'm married, I'm gonna have to split this. So I'm quitting 50%. Okay, I quit 50% claim to the property. I'm giving that claim to whoever joined me. Does that make sense? I have to quit or give up in order to add somebody to the title. And then at divorce, I'm going to quit the other 50. Unless I have the prenup, right? And how much do I get? 0. All right, but this is what happens. If you get married and you join forces and you already have a property, it's called a quit claim deed to add somebody. If you're removing somebody, it's a quit claim deed to remove that somebody. When you're retaining title, that's what happens. Quit claim deed. Now, here's the thing. What if I have no rights to this property at all? What do you get? Nothing. That's it. If the grantor has no interest, then the grantee acquires absolutely nothing. And the thing is, you cannot sue me. Because I told you right away, I'm quitting any claims. I didn't say I have any. If I was ever entitled to anything, that's what I transferred to you. If there is a right or a claim, or if it develops over time, great, you got something. If not, then hey, sucks for you. Yep. All right. A quitclaim deed is often used to clear a title cloud. So this happens, for instance, if you guys remember, before when I said I gave the property to Masha and then Masha goes to try to refinance or whatever, she never recorded it. She never notarized or anything. So did you really own the property? In the bank's eyes, no. So now you have to find me to correct the issue because you needed to have it notarized. You cannot notarize something that you did not sign, right? So you need to find me. A deed, so you guys know, a deed is only effective for that transaction. So if it's a year later, 2 years later, or even just a day later, and you need to find me to correct the issue, we need to create a new deed. So we would do a quitclaim deed where I'm saying, hey, I have no rights to the property. The only reason why we did this is to correct the previous deed. Does that make sense? So in this scenario, I didn't have rights because I had already sold it to you. But for you to be able to refinance, you needed to have a proper deed with a proper notarization and to be able to record it. That's when we use a quitclaim deed. Good? Thumbs up. Awesome. All right. Reconveyance deed. What does the word conveyance mean? Transfer. Great. So if it's reconveyance, what does that mean? Retransfer. Perfect. All right. Why would we retransfer something? Depending on the state you're in, mortgages are called deeds of trust. Okay. So a reconveyance means you getting the title back to you. You guys remember we talked about trusts, right? We had a question right at the beginning of today, right? We talked about the property being transferred to the trust. There's a beneficiary and so on. So there's a trustor, trustee, beneficiary, right? A reconveyance is when we transferring back from the trust to the individual. So the beneficiary, in this case, the lender, we'll talk about it better in mortgages. The lender notifies the trustee that when the loan secured by the deed of trust is paid off, the trustee returns the title to the trustor's property. So in a lien theory state like New Jersey, where a deed of trust creates a lien rather than transferring the title, a satisfaction of mortgage serves the same purpose. So it's a mortgage. Okay. The next one we have is a trustee's deed. And in the trustee's deed exists when a trustee sells the property held in a trust to someone other than the trustor. A trustee's deed, most commonly known as an auction, when there's a foreclosure. Let's say you did not pay the mortgage, right? In those states, it's not called a mortgage, it's just a loan payment. Here, it's a mortgage loan payment in Jersey. So when you don't pay the mortgage, they go to auction. It's called a trustee sale. Here in Jersey, it's called a sheriff sale. Okay, so in those states, trustee sale. So they're selling to a third party, not back to the owner. Why? Because the owner did not pay the loan. So they're selling forward instead of back. Okay, so that's called a trustee's deed. Deeds executed pursuant to a court order. This could be deeds executed by executors. Okay, Amir, no problem. By executors, by administrators, and sheriffs. So somebody appointed by the court, just like I mentioned, sheriff sale. For a sheriff sale to exist, that means that the judge said, hey, it's ruled against the defendant that didn't pay the mortgage. So sheriff, please sell this property at auction and the proceeds give them to the plaintiff, which is who? The lender. Okay, so that's a sheriff deed. It's appointed by a judge, right? That's why it's called deed executed pursuant to a court order. Let me know if you guys are good. We're done with deeds so far. Good, good. Yes? Great. Transfer tax stamps. In some states, they use stamps. They have to purchase stamps. In other states, it just goes in the recording that they pay the fee. So it's a check they have to pay. Many states, in fact, most states impose a transfer tax. That means when you sell the property, you are responsible for paying a fee to the state for selling the property. These are called grantor's tax or seller's tax. These states usually collect the tax when the deed is recorded. In some states, the taxpayer must buy stamps from the county recorder and affix them or attach them to the deed before recording. In other states, the court clerk or county recorder collects the appropriate transfer tax. Guys, make sure your cameras are on, please. There's somebody hasn't been on for a very long time. All right. Depending on local customs or the sales contract, the seller or buyer may pay the transfer tax or even split the tax. Now, in New Jersey, usually it's the seller's responsibility. We'll talk about it when we get to the Jersey portion. Usually it's the seller's responsibility to pay for it. But can it be negotiated? Everything can be negotiated. That's it. So we can split it. The actual tax rate varies and may be imposed by state, county, or even at city level. The rate could be $1.10 per every 1,000. It could be 55 cents per every $500 on the sales, right? So that varies. It could even be a percentage. From state to state, it varies. All right, certain deeds, such as the following, may be exempt from tax, meaning they don't pay this transfer tax. Okay? If I gift you a property, it's a gift. Do you have to pay taxes on it? Do I have to pay taxes on it? No, it's a gift. Like if I sell or if I give a property to my son or to my daughters, do they have to pay money? Do I have to pay? No, it's a gift. Deeds not related to a sale, such as change in the form of co-ownership. For instance, we were tenants in common. We want to become joint tenants. If we want to change, all of us have to agree. Obviously, you know the 4 unities, right? But you can change it. Is there a sale? No, it's just a change. Maybe it was under my personal name and I decided to transfer it to the business name. As somebody asked yesterday, can we put it under an LLC, right? Maybe I just want to transfer. Was it a sale? No, I have to prove. So we signed what's called an affidavit of consideration that explains why it was a gift or why it was a $1 transfer or why $0 transfer. Okay, so it's exempt from taxes. Transfers to and from or between government agencies, deeds by charitable, religious, or educational institutions, deeds that secure debts or release of property as collateral for a debt, partitions, tax deeds, deeds due to corporate mergers, or deeds from subsidiaries to parent corporations for stock cancellation. None of these transfer hands, except for the governmental ones, but none of these transfer hands, therefore, it's not a sale. Okay?
So as long as no money is being exchanged. Basically.
As long as you can explain why no money is being exchanged. Because all states require you to prove the nominal fee. If it's less than what the full value is, most states require affidavit of consideration that says, hey, it's $0 because. So yes, if it's $0, you just have to explain and then you don't pay the taxes. Yep. All right. So this was voluntary alienation. What does involuntary mean? Out of your control. It's not your will. So against your will, right? The next question is, which you know by now, should know by now. What is alienation?
Gotcha.
Detachment. Okay.
You have.
Yeah, it's detachment. That's it. In the simplest form, it is detachment. Alienation, detachment. So involuntary detachment. Don't leave me. Involuntary detachment. What is it? Well, it could be through natural forces like accretion, erosion, right? Accretion is addition, I'm sorry, or loss through erosion. It could be because you got right here, there's a few examples. Because of his cheat, you didn't have a will and nobody claimed it, so hey, it's gone. It could be eminent domain. It could be foreclosure. It could be adverse possession. Somebody took over your property. All these are examples of involuntary alienation. Okay? Who asked for nature to take away my property? Nobody, right? Who asked for the states to take away my property? Nobody, right? If you didn't pay your mortgage, hey, they're taking away your property. You didn't ask for it, but they're going for it. Involuntary alienation. That means without consent. Okay. So we talked about this yesterday. You guys can go back to it whenever you want. Involuntary transfer of operation law. Adverse possession, you already know that it has to be statutory period of years, right? Every state is different. So it could be 5 years, it could be 10 years, it could be 30 years, it could be 100 years. It has to be open, notorious, continuous, hostile, and adverse. So everybody, when you're doing adverse possession, everybody should know that that's what you're doing. It's open, notorious, known by others, visible, you're not hiding, uninterrupted, hostile, that means without the owner's consent, right? And against their right, adverse, their title. Cool, Shakir. You're back. All right. Are we good here with the adverse possession? Yes. Okay. We talk about tacking. Who knows what tacking is without reading? Tacking. Tack. Without reading. It's not a spelling bee contest. Tacking. I told you to write an S behind it to be stacked for stacking. What does it mean to stack something? Pilot, right? So tacking is the term used when you're piling up on other people's amount of time in that particular property. So I don't have to stay there for the whole 20 years. I can have somebody for 5, another person for 5, and then I take over for 10 years. And that still makes the 20 statutory years. So tacking is stacking upon other people's adverse possession time. Okay. Now, can you claim legal title just by saying, hey, I've been here for the statutory 20 years? Can you claim it just like that? No. To claim title, you have to file a court action. To claim title, you have to file a court action. What does that mean? It means no longer am I just using your property, I actually own your property. Simple as that. See, for the past 20 years, I've been using it. I'll claim the right to use it. And then later on, I claim the title to it. So 2 actions happen. Claiming the right to use it, that's adverse possession. And then claiming title to that piece of land where I cut from yours, added to mine. Okay. All right, next. Conveyance of a decedent's property. What does this mean? It means somebody died. Conveyance is a transfer of somebody, a deceased person's property. Now, if you died testate, that means you have a valid last will and testament. If you die testate, you have a last will and testament. If you died without a will, what is it called? Nope,
Oh,
without the testament, intestate. Testate, I have a last will and testament. Intestate, it was without a last will and testament. And these are the laws of distribution. Because remember, we got to go through probate, court action. Probate. What is probate? You died, court needs to know who are the rightful owners, or I'm sorry, heirs, right? And who do you owe money to? Okay? Because look, my kids are going to inherit millions of dollars, but they're going to inherit millions of debts too. Does that make sense? So we need to offset it and figure out how much they're really going to get. Okay? It's not just like, hey, here's millions. No. Offset it. Yes.
credit debt, like, let's say you don't have any assets, or anything, then you die, you owe a bunch of money. What does that debt get transferred?
So that's the thing. If you have nothing, you have a bunch of debts, it's unsecured debt. If it's unsecured debt, the term already says it all. They can't do anything. It's a loss for them. Like credit card bills.
Yeah, that's what I'm talking
Yeah.
about. Credit bill.
Oh, I'm not, if I die, I'm not worried about my credit card bills.
Like, it doesn't get transferred to like your family
Nope.
or. Nothing.
Nope, it's called unsecured debt. If it's secured debt, that's a different story. Secured debt, right? It goes to your heirs. The property goes to your heirs. It's secured by a property, it's secured by the car, it's secured by the business as a security, the inventory in the business as a security, and so on. So that could be transferred. Okay, so now we need to offset it by paying off the creditors first. And that's what we're going to talk about here. So you can die testate, that means you have a testament, intestate with heirs, or intestate without heirs, meaning nobody claimed it. If you die testate, then first, we're going to pay off the creditors. That's the first thing. Second, it goes to the legal life estate. So first we paid off the creditors, and there's $100,000 left. Now, depending on state law, legal life estate is the first one to get the first $50,000. Everything else is now split between everybody else. But who's the legal life estate? There's conventional life estate, there's legal life estate. Conventional is from me to you, transfer. Legal is spouse. So legally, your spouse inherits automatically property that you own, right? That's a legal life estate. We're not talking about transfer of property, like I'm selling the property. We're not talking about that. I'm talking about I die. When you die, now the state of New Jersey, for instance, now recognizes common law marriage, even if it's at time of death. So if it's somebody I lived with over several years, they're entitled to the first 50,000, and then it's split between the heirs, all of it. So that's how it goes. If you died intestate, meaning without a will, okay, the first thing we're going to check is, are there any creditors? That's the common element in all of them. Look, common element in all of them. Creditors got to get paid first. Whoever steps up to claim. Okay. Then the legal life estate, if there is one. Then it goes to the heirs by descent. What is descent? If you have a will, you tell the court how you want your assets to be distributed. If you don't have a will, then the laws of descent and distribution will say, well, in the state of New Jersey, first it goes to this person. If this person's not there, it goes to this person. If this person's not there, it goes to that person, and so on. If you have a will, you say, no, we skip all these people. I don't want to give anything to my family. It goes to somebody else if I want to. Okay? If there's no will, the state already has a table of how it's distributed.
That's like next of kin, right?
Whatever they determine to be. Yes, absolutely. All right. What if you die intestate without heirs? You have no heirs. Now it says cheat. But first,
Creditors.
creditors, always. Do you owe money? Does your estate, your assets, do they are is there any money owed? Okay, first, creditors. Then the state gets it by his cheat. Okay? We're good? Cool. So when the person dies, ownership to real estate passes to the co-owner automatically and becomes a sole owner of the tenancy by the entirety or joint tenancy with the right of survivorship to the persons named in the will or heirs as determined by laws of descent and distribution. Okay? When the title passes by will or descent, the estate must go through a judicial process called probate. We already covered that, in which the heirs to the property title is recognized. Usually liens against the estate must be satisfied before the designated individuals can take possession of the property. So we already went all over this, right? The party named in the will could be a trustee of either an existing trust or a testamentary trust established by will. We also mentioned that at the beginning of this chapter. And then transfer of title by will. Let's stay here for a second. What is a transfer of title by will?
You left to- like, in your will, you wrote who the title's gonna go to.
In the will, I wrote who the title is going to go to. Correct, right? But I'm alive. I'm not dead yet, right? I might look like it, I'm a little pale, but but I'm alive. So who gets the stuff that's in the will?
If you're alive.
Mhm.
Nobody.
Nobody. Exactly. So the transfer of property by will only happens after death. Okay, very, very important you remember this. Sometimes when you're, this is the trick. It's not like you don't know this stuff. I'm pointing out the obvious stuff most of the times. But when you're reading the question, just like that question about the trust, sometimes we get confused. The way they're worded, the way they try to trick you. So you got to remember, if it's a will, okay, or if it's a devise, which is a will, if it's a devise, that means after death. If the property was sold while I was alive, what do my kids get? Nothing. Okay? And they will put sentences like that. All right? Bruno put in the will the property on 120 Adams Street. Okay? A few years later, he sells the property. Upon his death, what do the kids get? And then gives you 4 options and it says the property on Adams Street. You see what I'm saying? They will trick you like that. So you got to pay attention. If there was a will, it's only after death. If the property was sold while you're alive, then they get nothing. Simple as that. Okay? If it's a deed, it must be delivered while you're alive and conveys the present interest on the property. Any property in the will can be transferred while the testator is alive. Okay? The parties named in the will have no rights or interests while the owner is alive. Very important. They have no rights or interests while the owner is alive. My kids cannot claim anything in any of the properties while I'm alive. Okay? Good? They acquire the property if still under my name, right? They acquire after I die. So when the real property is included in the will, this is known as a devise. Real property included in the will is a devise, and the parties to it are called devisor and obviously devisee. There you go. Wills that include personal property bequests are gifts of legacy. So if there's personal property, it's called legacy. If it's real property, it's called devise. Personal property, it's called legacy. All right. Now, I mentioned this yesterday. I mentioned it today again. And I think I mentioned earlier as well. A will cannot overwrite a state's dower, courtesy, or homestead laws. You guys remember I talked about elective share? Right, we talked about dower and courtesy. We talked about homestead, and we talked about elective share, where if I leave nothing in my will to my wife, I leave nothing, she can still claim 1/3. You remember that? Or half, depending on dower and courtesy laws. Okay, so a will cannot override dower, courtesy, or homestead laws. I can put 0, but they might still be able to ask for the elective, or also called minimum statutory inheritance. Elective or minimum statutory inheritance. This right is only available for a surviving spouse. Only a surviving spouse has this right. That's it. Kids cannot say, oh, he left nothing. It was my dad. Why is nothing for me? Like, they cannot claim it.
How come, like, the spouse is a little bit higher value than,
Yeah, she put up with me all these years.
and the kids didn't?
I put up with them.
I feel like it's equal. You put up
Listen.
with each other.
It's not the same. It's not the same. Unless you were supporting me somehow. I mean, not you, my kids. Unless my kids were supporting me somehow. No, they didn't pay my bills. They're not paying my bills. So they're entitled to nothing. The wife had to put up with me while one of us paying the bills or both of us paying the bills. So there was like a common ground here, you know? So yeah. Don't worry, I'll sell everything before I die.
Yeah, you know when you're gonna die, you have like a date
Of course.
first.
Yeah.
I thought you were gonna live forever, now you have a date to die, look at you contradicting yourself.
Listen,
Ah,
I didn't say I was gonna live forever. I've been on this earth for a long time. And I'll be here for a very long time too. Anyway. Requirements of a will. What do you think are the requirements to make a will? Without reading. To make a will valid, right? What do you think are the requirements? A lawyer? That's the first thing you got to say. A lawyer? A witness, maybe. Okay. Over 18 and of sound mind. That's the first thing. Nika says life. Yeah, to make a will, you have to be alive to make it. Yes. Very good point. You cannot prepare it after you die. Okay, it's a very good point. You know why? Believe it or not, sometimes the heirs create the will after the person died. That is illegal. That's jail time. They forge signatures as well. That's why a witness, like you said, is important. That's why maybe using an attorney to prepare it is important. Stephen is like, only if you get caught, of course. Yeah. How many of you know how to sign like as if you were one of your parents? Of course. There we go. Forgery is easy, right? That's it. Yeah. Just prepare the will now, so the paper looks like it's old. All right, that's it. Make sure you have a close relationship so you know your parents' assets, like what they actually own. Seriously. All right. So a will must follow the laws of testator's state of residence, of course. If the testator owns specific property. Shakir says my mom's handwriting sucks, so she always made me do it. Wow. Mhm. That's how she got out of school and all that stuff, doctor's notes and everything. Anyway, legal capacity is required to make a will. Therefore, a person must be a legal age of sound mind. Legal age varies from state to state. And for sound mind, testator must be mentally capable of understanding the nature and the extent of his property. Testator must understand that the property will go to those named in the will, who may or may not be the testator's natural heirs. Wills must be drawn voluntarily. You cannot be forced. Does this sound like something we talked about today already? Like what?
Signing the rights to the house.
Like a deed. Must be voluntarily, must be of sound mind, right? Technically, a will is a contract. These are the regular or the basic laws or basic elements of a contract, being of sound mind, right? Voluntary, of age. Does that make sense? All right. It says in many states, a will must be signed by 2 or more witnesses, and these shouldn't be the beneficiaries to the will. Of course, sometimes we make that mistake. Well, who am I going to use as a witness? You're my heir. You're right here. Just sign as a witness. Well, the other heir can say, I'm going to contest this will. Because it doesn't make sense. How come this beneficiary, my brother or my sister, is getting more than I am? Why are they getting that house and I'm getting this house? You know, so the disputes start. So the witness should always be a third party. Okay.
What happens when you contest the will?
What do you mean? What happens?
Like,
You might win, you might lose.
who this, like, how can you prove it if the person is dead beyond a reasonable doubt?
So yeah, well, that it's going to be tough to contest the will, obviously. But if one of the elements of the will was a beneficiary as a witness, it's going to be easy. Like I'll look at it like, oh, you got the mansion, I got the little Cape Cod. You know what I'm saying? It's going to be easy to dispute. Something is wrong here, right? But yeah, just like everything, it becomes difficult. So make sure you use third parties for everything. You get contracts for everything. You get notarized. You get everything the way it's supposed to be. What if the witness is not alive by the time the will comes into play? Now Jefferson's getting creative here.
That's interesting.
Okay. So granddad died. I killed dad, and there's just me. So what if? I mean, if the witness is not alive, then who are the heirs? Is there 1, 2, 3, 4, or no heirs? It depends, right? If there's 2 heirs, they can dispute still and say, "Hey, no, that was Uncle Fred that signed as a witness, and he was already mentally, compromised, and we got proof of that." If you can come up with some type of proof that that person was not a competent witness, or that the testator was not a competent person at the time, then you can always dispute, no matter what. How do you get that? Maybe you have something in writing. Maybe you have a doctor's note. Maybe the whole family agrees. Let's get together, a petition with 50 signatures that Uncle Fred was crazy, right? I don't know. Anyway, some states recognize oral or handwritten wills. Other states require witness written will to transfer real estate, specific to real estate though. Testators can change their wills while alive, and they should every single time. So a will is a living, breathing thing. I can write a will today. In 5 years, my life is going to be different. I need to amend that will. Okay. Transfer of title by descent. We already talked about this. This is the state determining right here who is entitled to inherit the property. That's all it is. You already talked about that. As a real estate professional, though, we should advise the client or customer to consult legal counseling before determining the descent or ownership. Every time you go to knock on a door that says, "Hey, I'm the holder of the estate or administrator of the estate," careful, okay? Make sure you have something in writing that actually says that this person is the administrator of the estate and this person can sell the estate, because the property does not belong to that person. It belongs to the estate. And I know it's difficult to understand this sometimes, but the estate becomes like a corporation. Remember before I said for a corporation to sell assets, there has to be an agreement, right, for an authorized officer. Here's the same thing. When there's an estate, it's a corporation. So somebody has to be authorized to sell the assets of the corporation or the estate in this case. Okay. All right, probate. We already covered that. The only thing I want to point out is this. The probate court acts on its own accord through the executor named in the will or administrator appointed by the court if there is no will. That means the court makes the decisions for you by reading the will or by appointing somebody if there is no will. They will determine the validity, the assets, they identify beneficiaries of that will or inheritance. Before any distribution, estate and inheritance taxes must be paid, and each state law governs the probate and the functions of those appointed by will or courts to administer the destines affairs. As I said, the real estate broker entering into a listing agreement got to be very, very careful, right? So one of the things we need to point out is that if it is an estate, the executor or administrator of the probate should know that the commission to be received must be approved by the courts. So whatever commission you're going to get, realtors, must be approved by court order. Sometimes we cannot charge 6%, 20%, whatever you want to negotiate. Sometimes you can't. Sometimes the court will say, hey, it's only $1,000, take it or leave it. Okay? And it's paid from the sales proceeds. A broker cannot collect commission unless the court approves that sale. In some states, the probate process is not lengthy or expensive, but in others it is. So property owners can avoid, I think Stephen talked about this the very first day. Sometimes we can avoid the expense of probate by establishing a trust all your life. Okay? This way, what changes when somebody dies? What changes? Just like a corporation, the only thing that changes is the beneficiary. That's it. So if it didn't change ownership, because the trust is the one that owns the property, because the corporation is the one that owns the property, if it didn't change ownership, then is there a need for probate? No. You guys got it? Give me a thumbs up. I got two thumbs up. There you go. Awesome. With that being said, we are done. Woo.